After an interruption in service due to the war in Ukraine, WIPO, the World Intellectual Property Organization, is once again accepting complaints under the .ua domain name dispute policy, although there are a few important changes that went into effect as of July 1st, 2023. As I discussed in a previous video, the .ua dispute policy is very similar to the UDRP, the Uniform Domain Name Dispute Resolution Policy, with a couple of differences, the most important of which relate to the bad faith element, which requires only registration or use in bad faith, and the language of the proceeding, which is typically limited to English, Russian, or Ukrainian. But the most important thing to know now, as I'm recording this video in July 2023, is simply that it's possible again to file complaints under the policy for .ua domain names, which, by the way, are limited in registration to entities that meet specific eligibility criteria, which is true for many CCTLDs, or country code top-level domains. The Ukrainian domain name dispute policy, which is administered exclusively by WIPO, was only created in 2019, but shortly after Russia's invasion in February 2022, WIPO issued a statement about possible delays or interruptions to .ua proceedings, and it eventually stopped accepting complaints altogether, which I understand was as a result of a decision by the Ukrainian CCTLD registry operator. Because of this decision, and earlier perhaps because of conditions created by the war itself, there were no .ua dispute complaints filed in 2022. Prior to that, the last complaint had been filed in November 2021, 3 months before the war began. Now, overall, there have not been many Ukrainian domain name disputes since the policy went into effect, with just 68 filings in the 3-year period that predated the start of the war. And although trademark owners can again file .ua complaints, there are a few changes to be aware of. And these were announced by Hostmaster Limited, which is responsible for the Ukrainian CCTLD, in a document that acknowledged the need to ensure the continued functioning of mechanisms for the protection of intellectual property rights under the legal regime of martial law. So first, a registrar now has an additional 14 days to respond to WIPO's verification request after a complaint has been filed. And that's in addition to the 2 business day timetable set forth in the rules for .ua disputes, although the registrar still must lock the disputed domain name within that initial 2 business day window. Second, a registrant can now request and will automatically receive a 14-day extension of time to submit its response to a complaint. And that's in addition to the 20 days already set forth in the rules. And third, a domain name registrant that loses a .ua dispute decision now has an additional 14 days to file a lawsuit in the courts of Ukraine to stop the transfer of a domain name. And that's on top of the 10 business day window already set forth in the rules. So the bottom line, as all of these changes should make clear, is that a .ua domain name dispute could take longer to resolve, because it's possible that as many as 42 days of additional time might be added to a Ukrainian domain name dispute proceeding. And given that many domain name disputes are resolved within only about 2 months, that's a relatively significant amount of extra time, although it does nothing to detract from the efficiency of domain name dispute proceedings, whether under the .ua policy or the UDRP, as compared with the prolonged periods of time required for in-court proceedings under traditional litigation. Finally, the changes to the .ua policy also include an important provision that could significantly alter not only the time period required for a case, but whether the dispute can even be resolved at all. The changes now provide that a panel may suspend a proceeding entirely if it concludes that the respondent is unable to exercise its right to defense at the time of the administrative proceedings, and if it is objectively impossible to consider the dispute without the respondent's participation. In reaching this conclusion, the registry's guidance says that a panel should consider the location of the respondent and how the domain name has been used after the introduction of martial law in Ukraine. All of these changes seem reasonable under the circumstances for a country that's engaged in a war for almost a year and a half. And while domain name disputes might seem trivial in the face of a war, there are obviously many individuals and businesses, both locally and globally, that rely on legal tools to fight cyber squatters online for their own protection and the protection of their customers, no matter what type of fighting may be occurring in the physical world. If you want to learn more about domain name disputes, please check out my masterclass, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.